All right. So France versus United States of America. Okay. So now that the metaphysical part is out of the way, we can talk more about international law strictly. Probably talk about this for 45 minutes and um, start part two next week. So this is a summary, okay, of the France versus United States of America international court case in 1952. As you can see, it says the United States of America in Morocco. Okay. Now this case has come. This is why we went in that subsequential order that we did. Law class 2 and 3 was over the French protectorate letters in 1913. It started in 1913. The letters when the French government went back and forth with the United States of America through a series of letters clarifying their position, right? So remember, United States basically said, hey, we realize you're trying to make us subjects of yours. And they're talking to the French government because France, being the protectorates over Morocco, that means that United States of America or United States, whichever one you want to say, in which in this case they use interchangeably again, you'll see what has been established. Okay, so again, this is in Morocco, United States of America. So we're talking about the de jure aspects of it in Morocco. This judgment should be cited as follows: case concerning rights of nationals of the United States in Morocco. Okay, rights of the nationals in Morocco. So this, it don't matter if you want to say U.S. nationals or nationals of any kind. The nationals of the United States. Why they say of the United States? Because they deem us as proteges and more subjects, in which they'll use they'll use different words to compare to the same people, just to let you know it's the same thing. Okay, so this could be deemed as U.S. nationals, but when we read this, we'll see that it's two Moors. Okay, it's about the Moors, and that whole U.S. national thing. Just to clarify that is another. It's kind of like they say U.S. national don't have to be a citizen, et cetera, et cetera. Well, that's for people like in Peru and stuff like that who are deemed as U.S. nationals, or not Peru, excuse me, but other places who are not a part of the North American continent, but the U.S. has jurisdiction over. Okay, so those are U.S. nationals, not Moors in their proper sense. So that really ain't no better than a U.S. citizen. That just means the United States has jurisdiction over you in a different area. You're in a different territory. You're a national of a different all that stuff. Still, you don't want to be a U.S. anything. You don't want to be American anything. No type of American. You want to be a Moroccan. You want to be a Moor, right? Independent and sovereign. So this case, what is this about? Well, it gives a summary right here. Damn. It gives a quick summary. It says economic liberty without any inequality in Morocco in the General Act of Algeciras. Okay, so we're talking about the General Act of Algeciras when we're talking about this case. So that's giving us indication where we need to start off with, right? So why are we starting off with this France versus United States of America case? Because it's pretty recent. Actually, it was one of the main things that the international law is focused, that the United Nations is focused on when it comes to the United States and Morocco. So this is a pretty common topic, a hot topic. General Act of Algeciras, right? That's giving us one clue. It also says effects on establishment of protectorate thereon. So it's talking about how France is a protectorate. It also talks about the effect of discrimination on the validity of residential decree, the consular jurisdiction in French zone of Morocco as based on bilateral treaties, most favored nation clauses, and multilateral treaties. So it's talking about the Treaty of Fez, it's talking about the Treaty of Peace and Friendship, etc. Okay, all that relate to France and Morocco and the United States. The meaning of dispute in Treaty of 1836 of Morocco and the United States, whether applicable of criminal and civil matters. So we're talking about the whole, relinquishment of jurisdiction, right? Who has authority, who doesn't? What's the true sense of that? The true depth of it, okay? Because a lot of Moors just think, oh, see, you relinquished jurisdiction, but we didn't read this whole case. We didn't read where that came from. That came from this case. They had to relinquish jurisdiction because it was court ordered to. From what case? This case. Okay. Remember, that was in 1956. This case is in 1952. So we got to read the whole case to get the whole understanding is that so-called relinquishment. Because remember, that was even it was codified in the judicial part, in the whole, what was that? 222141. It's codified under 121. I forgot. I got to get the correct codification. But some U.S. code to where it's similar to 141. It's like section 141 or something. But basically, it's codified under the judicial section. So it's talking about consular courts, not relinquishment of complete jurisdiction. They still have what's called capitulation regime. Okay, in which we talked about in the last video. So basically, yeah, they had to relinquish jurisdiction, but who is going to step up and take control of what they are stepping out of? We got to know government in order for them to leave. Basically, that's the only reason they haven't left. The only reason, literally, the only reason. So, the effect of renunciation by other states of consular jurisdiction, the effect of Convention of Madrid and Act of Algeciras on consular jurisdiction, custom, and usage, the right of assent to Moroccan jurisdiction as corollary of consular jurisdiction. So we're talking about the Act of Algeciras, the Treaty of Madrid. So this is why, excuse me, of course, it's saying that the Treaty of Peace and Friendship is important. That goes without saying, even though they'll mention it in this case. But, most Moors are not familiar with any other Moroccan treaties besides the Treaty of Peace and Friendship. They're not even familiar with the ones between Tunis and etc. So when we're talking about what this case is about, it gives leeway to what we'll be studying in our further classes, the Treaty of Madrid and the Act of Algeciras, because these will be the two treaties that we'll be mainly dealing with, and we'll go through history classes. I'll set up history classes so we can further understand the background of the Act of Algeciras and the Treaty of Madrid. Okay, I'll make those separate classes. We want to get real intricate with this, real intimate. Okay, so So we're talking about the right of assent. Okay, we're talking about a lot of jurisdiction and consular court. So let's scroll down, and we're not going to read the whole thing today. Okay, but let's start off what this says. Let's read what it starts off. It starts off saying. It says, okay, delivers the following judgment. Okay, the court delivers the following judgment. Right. So this is the summary of the court. On October 28, 1950, the charge d'affaires of France to the Netherlands filed in the registry, on behalf of the government of the French Republic, an application instituting proceedings before the court against the United States of America concerning the rights of nationals in the United States of America in Morocco. So France started this off, right? They registered this, right? The application referred to the declarations by which the government of the United States of America and the French government accepted the compulsory jurisdiction of the court in accordance with Article 36, Paragraph 2 of the court statute. It also referred to the Economic Cooperation Agreement of June 18, 1948 between the United States and France, and to the Treaty for the Organization of the French Protectorate in the Sharifian Empire. So it's talking about the Treaty of Fez, right? In 1912, that's what made France protectorates in Article 6 of the Treaty of Fez in the Sharifian Empire. So now we don't have to go through random English books, random English authors. We have our own valuable presentation because now we can use counterintelligence to explain to anybody, even in our own case, where we are, who we are, what we dealing with. It's the Sharifian Empire, right? Moors in the Sharifian Empire. Signed at Fez on March 30th, 1912, between France and the Sharifian Empire. It mentioned that the Treaty of Peace and Friendship of September 16th, 1836, between the United States and the Sharifian Empire, as well as the General Act of the International Conference of Algiers of April 7th, 1906. Okay. So again, this General Act, you might want to study that in your own time. Pursuant to Article 40, Paragraph 2 and 3 of the statute, the application was communicated of the government of the United States, as well as the states entitled to appear before the court. So we were entitled to appear before the court because it says the United States and the states entitled to appear before the court. Well, where were we at? It says Sharifian Empire. What are Moors? It's the case between France and the United States of America. What are Moors? Why is France even doing this? Because they're the protectorates, right? This is custodial work. That was a part of the agreement. So, what was that? It goes to say, pursuant to Article 40, Paragraph 2 and 3 of the statute, the applicant. Next paragraph. The time limits for the deposit of the pleadings were fixed by order of November 22nd, 1950. The memorial of the French government, which was filed on the appointed date, quoted several provisions of the General Act of Algiers and drew conclusions therefrom as to the rights of the United States. So based on this General Act of Algiers, there were certain things that came to a conclusion based on what the United States can do. The construction of the convention, to which the United States, other than those concerned in the case, were parties being thus in question. Such states were notified accordance with Article 63, Paragraph 1 of the statute. For this purpose, notes were addressed on these dates to those countries. Okay. it goes to say on June 21st. Now, this is where we can kind of get more detail with it right here. On June 21st, 1951, within the time limit fixed for the deposit of its counter memorial, the government of the United States of America filed a document entitled Preliminary Objection. Now, y'all remember when in those letters we discussed in Law Class 2 and 3, where the United States filed a preliminary objection. Remember we discussed that? In which they had made an objection, okay, in which was denied. But well, let's read, okay. The proceedings on the merits were thereby suspended. Okay, there you go. The preliminary objection was communicated to the states entitled to appear before the court, as well as the states which had been notified to the deposit of the application pursuant to Article 63 of the statute. The proceedings thus instituted by the preliminary objection were terminated following a declaration by the government of the United States that it was prepared to withdraw its objection, having regard to the explanations and clarifications given on behalf of the French government. So basically, since France clarified what was going on, it was suspended. And it goes to say, in order of October 31st, 1951, placed on the record that the discontinuance recorded that the proceedings on the merits were resumed and fixed new time limits for the filing of the counter memorial reply and rejoinder. Okay, so basically the rejoinder is when the United States left the whole situation. They left this case. So basically, by not following up with the proceedings, the correct proceedings, they dismissed themselves from the table. Okay. So now that they're brought back to the table, right, due to this case that France initiated, right, this is the rejoinder. Okay. The counter memorial reply were filed within the time limits thus fixed. As regard the rejoinder, the time limit was extended at the request of the government of the United States from April 11th to April 18th. Okay, so this goes to say a lot of other random information about who filed and etc. Now it goes to say, on behalf of the French government, may it please the court to adjudge and declare that the privileges of the nationals of the United States of America in Morocco, so we got to explain that triple entendre, right? Got to say in Morocco, the nationals that's in Morocco, so it's not just talking about U.S. nationals, it's talking about the nationals that's in Morocco, right? Moorish nationals. Are only those which result from the text of Article 20 and 21 of the Treaty of September 16th, 1836. So, of course, we're talking about Moorish nationals. Those are the only ones that apply, not U.S. nationals, right? So, in that sense, the most favored nation clause contained in Article 24 of that said treaty can no longer be invoked by the United States in the present state of the international obligations of the Sharifian Empire. There is nothing to justify the granting of the nationals in the United States of preferential treatment, which would be contrary to the provisions of the treaties. That the government of the United States of America is not entitled to claim that the application of all laws and regulations to its nationals in Morocco requires its express consent. So basically, the United States, or the Moors in the so-called United States of America, do not need permission of the United States to be who we say we are. We don't need permission for a government. We don't need to go through them for a government. We don't need to recognize this, all that stuff. Okay, so we already know that they not gonna acknowledge it in its full-hearted extent. We already know. So we set ourselves up for this, but we got to set ourselves up first, right? So um, it says that the nationals of the United States of America and Morocco are subject to the laws and regulations in force of the Sharifian Empire, and in particular, the regulation of December 30th, 1948, on imports not involving an allocation of currency without the prior consent of the United States of America, United States government. Okay, so we can abide, we can just go enforce our laws, but how you enforce that? You gotta have a state, you gotta have a government. That the decree on December 30th, 1948, concerning the regulation of imports not involving an allocation of currency is in conformity with the economic system which is applicable to Morocco, according to the conventions which bind France and the United States. Um, that Article 95 of Acta Algeciras defines value for customs purpose as the value of merchandise at the time at the time and at the place where it is presented for customs clearance. That no treaty has conferred of the United States fiscal immunity for its nationals in Morocco, either directly or through effect of the most favored nation clause. Okay, so they have not established any bridge that they have the right to be doing what they're doing. Again, this is how we talked in class 1, to where in order to call yourself a Moorish American, there has to be a citizenship clause that says, hey, I can exercise, or, say I'm of dual citizenship, et cetera, all that type of stuff. But there is none of that. There's none of that. All there was, hey, we have a treaty of peaceful friendship. And next thing you know, we have the Americans running engineering, social engineering society, and everybody think they're Americans now. So now more say Moorish Americans because COINTELPRO. That's the only reason more say Moorish Americans. They'll take the picture that Noble Drew Ali had with Morocco and United States Americans say a Moorish American. The picture. Not understanding everything else said in between that in regards to international law. Like you really got to be fighting this cognitive dissonance to think that Noble Drew Ali exercised every move on behalf of the temple only and not the nation. And when he went to the Geneva Convention, he's not reading the Act of Algeciras that was in 1906. It says every state needs a constitution in international law. So if every state needs a constitution, this is him. Just imagine him explaining to everybody. If you see the Moors now not anxious to start a state, imagine back then. He had to mimic it on the most mundane levels to say, okay, at least do this in a business aspect so you can understand what it starts to take, even though it's a little different in international law because we're in somebody else's law practicing, right? Starting to bloom out. Some of us stayed there, right? But the other half has not been told it's international law, in which is the highest tier. So let's skip down. Okay, well, actually, let's finish reading that. That the laws and regulations of the fiscal matters which have been put into force in the Sharifian Empire are applicable to the nationals of the United States without the prior consent of the government of the United States. That consequently, consumption taxes provided by the Dahir of February 28th, 1948, have been legally collected from the nationals of the United States and should not be refunded to them. Okay, so this goes into the Act of Algeciras, how a good portion of it was basically because the Moroccans needed a state bank. Okay, the Moroccans needed a state bank because at the time, and we'll go have our own history class over this. I'll show pictures from books and stuff. At the time, the Sultan was not highly favored. He was not highly intelligent in the international arena. So there were certain things set up in which allow France, being a protectorate, to handle our affairs in terms of finance. Okay, so this is about taxes too, consumption taxes. That's what this case is about. Okay. On behalf of the government of the United States, the submissions and conclusions presented by the French government in the case should be rejected on the ground that the French government has failed to maintain the burden of proof, which it assumed as party plaintiff and by reason of the nature of the legal issues involved. So basically what the United States is saying, the French government has failed to prove that they are party to the Treaty of Peace and Friendship, in which they're not. So, but their argument only has so much weight because France has their power of attorney over Morocco at the time, right? So they're looking like, what are you talking about? So they're trying to use anything they have. They have to use this treaty. So we're gonna explain how they use this treaty. The treaty rights of the United States and Morocco forbid Morocco to impose prohibitions on American imports, save those specified by treaties, and these rights are still in full force in effect. Right. So as of 1952, right, they saying certain rights are still in force and effect. Okay, they're admitting some things from the Treaty of Peace and Friendship. Now they know what it is, huh? Now they know how to use it. In 1952, the Dahir of December 30th, 1948, imposing a prohibition on imports is an indirect contravention on the treaty rights of the United States, forbidding prohibitions on American imports in the French government by applying the Dahir of December 30th, 1948 to American nationals without the consent of the United States. From December 31st, 1941 to May 11th, 1949, violated the treaty rights of the United States and was guilty of breach of international law. American nationals cannot legally be submitted to the Dahir of December 30th, 1948, without the prior consent of the United States, which operates to waive temporarily its treaty rights. So this is the United States saying this. They're saying, hold on, whoa. American nationals, they call this American nationals cannot legally be submitted to the Dahir, etc. And we have to ask the United States, which is not true. The jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. So they're trying to not mention this more word. They're acting like it's just a treaty between American citizens and the United States, it looks like. In addition, the United States acquired in Morocco jurisdiction. Let me start that over. In addition, the United States acquired in Morocco jurisdiction in all cases in which the American citizen or protege, now they're saying protege. Now they ain't saying more subject now. They're trying to stay away from this war word. Remember, Moors are deemed as more subjects and proteges. And here they go trying to call us American citizens because we're deemed as United States citizens. Right? But France is trying to be particular with them, saying, hey, by law, these are not U.S. citizens. We're only saying that because of by basically their ignorance that you're allowing that, and nobody else is here to speak on their behalf, but you and this whoever's typing behind this pen, right? So this is the so-called good faith, right? So the Dahir, or It goes to say, in addition, the United States. Oh, okay, I read that too. Such jurisdiction was not affected by the surrender of Great Britain in 1937 of its rights jurisdiction in the French zone of Morocco. Okay, we gonna read in the history class more about what Germany thought it is, France, the true intents, France, Germany, England, what was going on, why these treaties were created, the consciousness of them at the time. Okay, such jurisdiction has never been renounced expressly or impliedly by the United States. Under the regime of extraterritorial jurisdiction, now exercised by the United States and Morocco, United States citizens are not subject in principle to the application of Moroccan laws. So they're trying to use these United States citizens are not subject to Moroccan laws. So they're trying to call you United States citizen or a protege and say you're not subject to these Moroccan laws because there's no Moroccan laws in the United States. Right? And also they're not subject to them because they're United States citizens, they're American citizens. Why would they be subject to them? That's how they're trying to act like. So they're saying these United States citizens or American citizens or proteges, remember it's all the same thing according to them, are not subject in principle, because we haven't aligned ourselves right in principle. You don't have your state government to have Moroccan laws applied to you. Right? So this is kind of like, look, let's pin a tail on the donkey, okay? There's no such thing as operating in private law while being in somebody else's house or government. You can't be in a private room. You think you're in a private space, but they the one that built that house. They know every speck of that house. They know the codification of the little knob it took for you to get in that little door you think you hidden from. Small victory you think you got. No, look, we got to stop with that. There's no such thing as operating in private law, in de jureness, in truth, while in the United States government. So all the Moors talking about, yeah, we need private law, private. We just gotta be private. No, look. You trying to separate church and state. You got that whole type of effect going on. No. Supposed to operate as one, just like the Moorish Science Temple of America is supposed to operate as one with their state government, their Moorish state government. There's truly supposed to be no separation. Truth between private and public, church and state. Okay, so we'll give this 10 more minutes. Such laws become applicable to the United States citizens only if they are submitted to the prior assent of the United States government, and if this government agrees to make them applicable to its citizens. The year of December 30th, 1948, not having been submitted to the prior assent of the United States government, cannot be applicable to the United States citizens. So here we go to the permission thing, which we don't need. We don't even have to come to them to set up a government. So what is the point? And I'm gonna make a video, another video explaining the process of the lion laying with the land, or us transitioning into how will everybody know that we're more state government? Will it just happen? Everybody know at once? What is the process of us developing? What is the reality? What does that look like? A lot of Moors think it's just gonna be boom, bam, we just step into every building and just take over. No. It's a due process to everything, in which they'll try to hide as much as they can. But the only reason a lot of these governments getting out of the way now is because we're stepping into place. It's gonna trickle just like that for every business, every etc. It gets caught up slowly, frequency by frequency, line by line, one by one, whatever, however many get out the way at once. Whether it's this type of corporation, the IRS, or whoever, He'll start to get out the way slowly and surely, make a space for Moors to do what? Step right in these buildings, right? All while it's a due process to many laws that this gonna it's gonna seem like a lot is going on basically. But once you read what few laws are being enforced at the time, it'll be easy to organize your mind and see what's going on. Okay. So the only way, this whole Noble Drew Ali saying prepare for 90 days for food, all the negative stuff that's yet to come. The only way that you're gonna be saved is by what? Well, if you're a Christian, Jesus, right? Muslim, if you, Muhammad, right? Or maybe some people even Noble Drew Ali. You know what I'm saying? Some people call him Jesus. So, and this is nothing we gotta kill. Let me just nip this in the bud. Some people be worshiping stuff, and they trying to make a reality based off of this. The term theocratic state. I built with Moors, and I heard the term theocratic state. Oh, the Moorish Science Temple of America is a theocratic state. Whoa. No, it's not. Now you're trying to change up what the literature stuff Noble Drew Ali said. You're trying to do COINTELPRO work now by saying theocratic state. Because he clearly said this religious organization. It's a religious organization. There's a difference between an organization and a state. Okay, just like there's a difference between nation and state. It's the term nation state, right? So what is the United Nations? It's an organization of independent states. Hence you got to decipher the two. It's not a government, it's not a state. It's an organization of independent governments or states, right? So what's a theocratic state? Well, that's a state. It is an actual term, a lawful term, a legal term. But to say that's the state that you need, because it has to align with international law. Again, so if you're trying to stick with the Moorish Science Temple of America, saying it already has what it do, you ain't got to go to the UN. Well, if you ain't gonna deal with the UN and put yourself on notice, then what you talking about theocratic state for? All of a sudden, you see, because if it's a theocratic state, then okay, then tell the United States, as you've been doing, it's a theocratic state because you think that you need permission or to put them on notice. Just as this document has been explained, they're taking the consciousness of the United States, saying, yeah, they need our permit, they got to go through us. No. France already said we ain't got to go through them. So what are we going through them? We're sending paperwork. France knows this. They have a lot of power in the United Nations. So the war send paperwork to the United Nations. They're like, what? Look at the case, man. Look at the case. Just look at the case. That's all they said. So I'm gonna read this last little bit, and then we can get into question and answer and comments and wrap it up. It says, as a counterclaim, number one, the United States, or under Article 95 of the Act of Algeciras, the value of imports from the United States must be determined for the purpose of customs assessments by adding to the purchase value of the imported merchandise in the United States the expense incidental to its transportation to the custom house in Morocco. So it's talking about who's the merchandise. It's talking about us, the subjects. Okay, these businesses, right? This merchandise, these vassals. So, exclusive of all expenses following its delivery to the custom house, such as customs duties and storage fees. It is a violation of the Act of Algeciras and a breach of international law for the customs customs authorities to depart from the method of valuation, so defined and to determine that the value of imported merchandise for customs purpose by relying on the value of the imported merchandise on the local Moroccan market. The treaties exempt American nationals from taxes. So there you go. Wars and taxes. You want to be exempt, use the treaty. Okay. Except as specifically provided by the same treaties to collect taxes from American nationals in violation of the terms of the treaties is a breach of international law. Such taxes can legally be collected from American nationals only with the previous consent of the United States, which operates to waive temporarily its treaty rights, and from the date upon which such consent is given, unless otherwise specified by the terms of the consent. Consumption taxes provided by the Dahir of February 28, 1948, which were collected from American nationals up to August 15, 1950, the date of which the United States consented to these taxes, were illegally collected and should be refunded to them. Number 3, since Moroccan laws do not become applicable to American citizens until they have received the prior assent to the United States government, the lack of assent of the United States government to the Dahir, February 28, 1948, rendered illegal the collection of the consumption taxes provided by the Dahir. Okay, so we'll go into the next, the rest of this, okay, in next class as we finish this last few sentences. The court will first deal with the dispute relating to the decree issued by the residents of General of French Republic in Morocco, dated December 30th, 1948, concerning the regulations of imports in the French zone in Morocco. Okay. So kind of read along or read ahead for next class if you want, starting on page 10. But as we have read so far, that the Act of Algeciras, right, the Treaty of Madrid, are two treaties, Moroccan treaties, that are of importance. As we seen at the beginning of the video, that a convention is a treaty. So these Montevideo conventions, these are treaties. Okay. These international agreements, these are treaties. Okay. Right. So it's important to keep in mind as we go through this case, the foundational standpoints, and not get lost into the different name calling. Okay. The American citizens, the protege, the nationals in Morocco, the Moorish subjects, don't get caught up into thinking one is necessarily different than the other. Okay. Into which it is, and that's the whole reason it's a different word. But a lot of those words are under the same umbrella. Okay. So ironically, they don't say, they don't say we're Moorish subjects, but the term Moorish American was a gift and a curse for us. Okay. Because that woke people up to another side of reality. Okay. That integrated. Remember how we talk about integrated, that temporary point, that integrated another consciousness. Even though it's COINTELPRO, even though it doesn't say anything in the treaties, it was used to nonetheless, whether it was good or bad, does not matter. We know that it does not carry value in international law, only the term Moroccan or Moor. So you're not taking anything away from so-called Moorish American by saying you're not Moorish American, you're Moor. Not taking anything away. What you're saying is, let's be correct. Let's be simple and plain. Okay. And the only people that really need this talk are Moors that believe they're ready, because out of that we can extract the true ones that are ready, in which there's only a few. There's only going to be, you can count them on one hand. And that know what Jolly said? This whole 144,000 deal, right? So, with that, I will leave the floor to y'all and ask y'all if there's any questions, comments, concerns, etc. before we end this. Okay. All right. So, I enjoyed the video. So since nobody has anything to say or anything, we'll conclude that with this law class number 4. I'll post it on YouTube, and I will build with you guys next Sunday. All right. So I'll holler at y'all then.
Thanks, Tim.
All right. Peace, y'all.
Thank you so much. This
Peace,
was
peace.
great.
Oh, thank you. Peace, peace. I'll talk to you soon, yo. And you can hit me up too, if you want to build some more, because I know it'll be good before.
Thank you. Yes, when I'm ready, I'm definitely going to getting some more like research done.
Okay, right on. Okay. All right. Well, yeah, just hit me up and I'll talk to you next class or sometime soon. Yeah.